Good, thanks very much, everyone. We'll just pick up where we left off. At page 10, you'll see the heading, the Senate's Responsibilities and Powers. Just note, I was typing this part of it on Sunday in my office, and in paragraph 35, in the last line, I say at the Senate's discretion. It should be at the board's discretion. Ooh. Ooh. Yeah, that was probably around 5:45 when I was getting there.
Like it that way then. Yeah.
I'll be happy to phone up Christy Clark. She won't take my call, but I'll be happy to phone. So, as has been obvious from my comments, one of the key themes here is this notion of autonomy and of the fact that powers and authority, whether they're exercised by the Senate or the board or the president, belong to the individual or body, or the office, a better way of putting it, or the body with those powers. I was chatting with one of you during the break, and as I mentioned earlier, as I understand it, John is going to get me to do something similar for the board. And I don't have a brief here. I will give substantially the same comments to the board as I'm giving here today, obviously with a slightly different emphasis because the focus there will be on the board's authority and powers, and so it'll be a bit of a shift of the focus. But this is the statute speaking. It's not a matter of personal preference. It's not, as I said earlier, a matter of politics. It's the statute. It's why earlier, and I made this comment at the break, I try and stay away really from talking about something being political in nature. What we're talking about is a governmental function. And there's a difference between politics and government. It sometimes gets lost sight of, obviously, in our society, and particularly given the media's desire to make a story out of whatever is happening. But we're not concerned with those sorts of politics or that sort of government here. And so the function, whether it's the board or the Senate within their areas of responsibility, is first and foremost a governmental function. We live in a country which has as its constitutional rubric, as some of you may know, the notion of peace, order, and good government. And that really is, in a sense, I suppose, the one perspective I'm advocating today is, and as I say, it's the same one I would advocate with the board, is that the exercise of power be in the interests of peace, order, and good government, as opposed to the fractiousness that often attends politics. That's not to suggest there aren't going to be significant issues of real and important principle where small p political perspectives aren't important. But at the end of the day, in my view, what the bicameral governance model contemplates is a level of governmental maturity that will allow the participants to step outside those sorts of parameters when the time comes, and to formulate, if not a consensus, at least a functional arrangement. As I say, that's why I think Kolchitsky's quite an interesting case, and we'll look at it a little bit again. It's a situation where that had broken down completely over such a long period of time, clearly to the complete detriment of the institution. And I, as said at the break, I don't know who was right and who was wrong. It's a bit like a divorce, at some point, it doesn't matter who's right and who's wrong anymore. People just are into the fight when it's all gone badly. And you get that sense reading the Ontario Court of Appeal's decision. It wasn't a matter of who was right or wrong anymore. These people just couldn't agree with each other, and the institution, the thing presumably all of them cared about, was paying the price, and potentially paying the price at a pretty fundamental level. So back to the paper. As is noted above, I'm just paragraph 32, the Act establishes the Senate at Kwantlen and allocates the powers that are necessary for the Senate to discharge its responsibility. In considering this matter, it's important to note that for the purposes of determining the responsibility and powers of a Senate, the Act recognizes 3 university groups, and I commented on that earlier. It's just important if for some reason one of you has occasion to really consult what the statute says to make sure it's the right section. The person I was talking to at lunch had obviously read the statute fairly carefully because he was alive to some of the peculiarities of the section that governs a special purpose teaching university as opposed to the senates at some of the other universities. And there are some peculiarities. My understanding is the drafting of the amendments to the University Act to allow for the establishment of the special purpose teaching universities was done fairly quickly, and there was an element of cut and paste to it. And as a result, some of the integration isn't optimal. Although I commented earlier that the provision that the court commented on at UBC about the way in which the power would be exercised between the Senate and the board doesn't exist at a special purpose teaching university. I actually don't think much probably turns on that. It's probably an oversight, and it's why I picked up the comment in the Court of Appeal, picking up the Ontario Court of Appeal's comment that one would expect the board and the Senate to discharge their responsibilities cooperatively. In other words, it shouldn't take a statute telling them to do it for it to happen as much as possible. In our case, it's the provisions of Section 35(2) of the Act that deal with the Senate. I note that 35(2)(1) requires Kwantlen to have a Senate. That's an important provision, again, deceptive in its simplicity in one sense, but it makes it absolutely clear that the Senate must exist. There can't be a Kwantlen without a Senate, and so the Senate has a clear legal authority for its existence. It's not open to the board or the president or convocation or the chancellor. It's not open to anyone to say we won't have a Senate anymore. 35(2)(2) describes the composition of Kwantlen's Senate, and it consists of both ex officio and elected members. The ex officio members, as many of you will know, are the chancellor, the president, the VP academic, deans of the faculties, the chief librarian, and the registrar, and then by election, 2 faculty members for each faculty elected by the relevant faculty members, 4 students elected by the students, and 2 support staff elected by the support staff, and then of the alumni, and at the board's discretion, 1 non-voting member. 35(2)(5) sets out the Senate's powers and duties, which include but are not limited to setting the criteria for the academic distinctions awarded by Kwantlen, setting the curriculum for the courses of study offered by Kwantlen, setting qualifications for the admission and withdrawal, setting policies to govern the examination and evaluation of students, setting criteria for matters related to academic standing, and setting policies and procedures for appeals by students on academic matters, and establishing a final appeal tribunal for those matters. Powers and duties in this section belong to the Senate alone and form the core of its authority over Kwantlen's academic governance. I'm going to touch briefly on the appeal jurisdiction because it's slightly different in my view at Kwantlen or the other special purpose teaching universities than it is at the other universities. And I say that because 35(2)(6) then contemplates areas in which the Senate must advise the board and the board must take the advice of Senate, but where I think it's clear as a matter of necessary inference that it's the board that develops the educational policy in question, not the Senate. And there, one of the matters in question is the appeal jurisdiction over non-academic matters of student conduct. So as I say, that's a slightly different model than exists at the older universities. That takes us to Section 35(2)(6). As I've said, in my view, it addresses matters on which the board ultimately has the authority to issue the educational policy in question, but where a precondition to the board doing so is that it takes the advice of the Senate, and where it is mandatory, but also the Senate's right to give its advice. It would be difficult to imagine a clearer example of where a cooperative approach is required. Cooperative doesn't mean full agreement or perhaps any agreement at all, but it does obviously mean that where one body responsible for aspects of governance is told, in effect, to consult with the other, and the other is told, consult with them, that there will be some, as I call it, governmental maturity around that exercise. Yes?
You said that the Senate, you used the word take when you said the Senate, or the board must take advice from the Senate, but it says here must seek advice.
Yeah, sorry. Yeah, I mean, I think, though, that implicit in all I mean by my use of the word take is that the board will, in good faith, approach the Senate and ask for its advice. And when I say take its advice, receive it. That's all I'm really getting at when I say take the advice. And I think that's quite clearly the board's obligation, and similarly, quite clearly, the Senate's obligation to give advice to the board. So, yeah, don't read more into my use of the word take than I'm meaning. But I think if the board was to deal in a perfunctory way, and I would say the same thing, by the way, about the Senate, but we're talking here about what the board's obligation is. If a board member asked me this, I'd say, well, it's more than a perfunctory exercise. It's more than going through the motions. It's more than simply ticking a box. Oh yeah, we asked the Senate for their advice.
And then what happens when there is a disagreement?
Well,
when advice has been received and taken into consideration?
Yeah, that's why I say I think the necessary implication of the way this is phrased is that ultimately it's the board which has the right to develop the educational policy. And so, I mean, I'm going to make a facetious example up. The Senate says, well, let's declare a day of holiday when the sky is blue, and the board says, no, we'll do that when it's overcast and raining. And ultimately, the board's view would prevail because the Senate's function here is advisory. The board's obligation is to obtain the advice of the Senate, but it's the board clearly which develops the educational policy. And sorry, just if I can close the loop on that before the next question. And so, but my view, and I want to stress this. I mean, and I think this is where a court would end up if there was a fight around this language. A consultation requirement in law is something to be taken quite seriously. You look with First Nations now, where the obligation to consult with First Nations has come into existence as a constitutional matter. That's given pretty significant effect by the courts when there's a fight over whether the consultation has occurred. It's not a matter of the court saying, well, hey, you tick the box, that's okay. There's an expectation that, you know, there will be diligence in seeking the advice. You know, I'm now translating it to our circumstance. Diligence in seeking the advice, that the advice will be carefully considered, that there will be reasons for not following the advice. So I like your word, receive the advice of the board. And that's, I say, the only connotation I meant from take the advice would be the act of obtaining the advice of the Senate. But it can't be perfunctory, you know, and particularly in my view where there's a disagreement. You know, if I was asked for an opinion, we have a disagreement with the Senate on this issue, I would be saying, when giving that opinion, that there has to be a careful, considered, good faith consideration of the advice, and if it's going to be rejected, very good reasons for doing so. Similarly, if I was asked for an advice, you know, or for an opinion by the Senate on giving the advice, I would say the same sort of things. You know, it can't be perfunctory. This has to be thoughtful and reflective. There can't be a stubborn refusal to give the advice because the Senate anticipates the board won't accept it. You know, this is coming back to my sort of notion of governmental maturity. This is meant to be done in that sort of context. And it is a clear example, I think, of where a cooperative relationship is required, even in the face of disagreements. Yeah. And sorry, there was a question just behind you. Are you sure? Thanks. Yeah.
I wonder if I could just jump back a couple of paragraphs to
Yeah, sure.
paragraph 35 about the composition of Senate. It talks about the composition here, and yet over time, I think Kwantlen Senate has decided that certain other people will be members of Senate. Do we have the right to do that, or is it strictly the members who are outlined in the Act?
Strictly the members who are outlined in the Act.
And so if we decide to have a second vice chair, that's...
The Act doesn't provide for that. The slight complication there is that the Act does contemplate that Senate will set procedures for the management of its meetings. I'm sorry, I've forgotten the exact phrasing. Here it is, 5A, regulate how its meetings and proceedings are conducted, including determining the quorum necessary for the transaction of its business, and how a vice chair who is to chair meetings in the absence of the president is annually elected. Clear authority for there to be a vice chair. Normally, the implication of something being spelled out expressly like that in a statute is that's the scope of the power on that issue. If a Senate were to unanimously decide that it was going to have a vice chair, I'm stressing unanimously because then there's no particular dispute for the current year. Probably that's not in compliance with the Act, but it's not clear-cut either. But I think the minute there was a debate about it, if I were a senator, I'd be concerned because I don't see any statutory authority for a second vice chair. There's a general authority to regulate proceedings. Could go either way.
And I guess the same thing goes for extra members of Senate who may have been added along the way.
Well, they have no authority. I mean, the membership of Senate is set out in black and white, and it begins and ends there. And the same is true of the membership of the board. It's set out in black and white. If you're not listed there in 35.2.2, which says the Senate of a Special Purpose Teaching University is composed of the following. It's a very specific list of, I say individuals, it's really offices and then ex officio and then the elected members. But it's, for example, I'm just picking this one out of the air, 4 students elected by the students, not 6 students elected by the students. So if the students suddenly said, oh, well, we brought a couple of extra people along, they've got no authority. And it has significant implications. I mean, we're talking about it in a fairly quick way, but let's suppose there's a close vote in Senate on an important matter. And I don't know whether these people are actually there, voting and so on, but let's suppose there's a close vote on something, and then there's an issue about whether the vote would have passed without these notional extraneous members. There's no validity to that vote in all likelihood. There's potential for a significant legal challenge. People with my strong sense is a judge faced with that challenge would say, well, I make my example up. The president will pick a kind of easy target here. The president says, well, I insist on the associate vice president, student affairs. We'll pick Jody, she's in Calgary. I insist on her having a seat at Senate. And it's Jody's vote that some important educational policy turns on. It's a big problem. So, my view is no, the composition of Senate is very clearly spelled out. And if you're not, on that list in some sense, I don't see how you have any authority as a senator. Yeah, that seems to me the case. Yes?
Patrick, sort of on the same lines, we're going through a situation right now where we have 2 faculties becoming one,
right,
and we're getting a change in representation.
Right.
What ability is there for a Senate to determine a transition period or plan when it comes to the people or the senators representing those areas when there's questions around when that's all going to take place? Like it's really muddy right now.
Yeah, I agree. And I think there are 2 competing perspectives on that. And one is linked to the statement about the term of office for a senator, which is 3 years, if memory serves, in this particular case, and the lack of any provision for the sort of situation you're talking about. It contemplates that there might be a vacancy, but when you look at what vacancy might mean in the legislation, it quite clearly doesn't really contemplate the sort of situation you're talking about. It's somebody getting hit by a bus out there on whatever that street is. So that's the sort of argument on one side, is you're elected, or I guess the deans would be the other one, could be the elected faculty, could be the deans. You're elected or you're appointed ex officio, term is 3 years. We'll assume for the sake of the discussion we're 2 years into the 3-year term. Nothing in the legislation seems to suggest that the term ends. On the other hand, and this is probably the view to which I lean, there's kind of fundamental problem with what is it you represent. Because as I understand the situation, and tell me if I've got it wrong, we've got 2 faculties that the Senate has decided to dissolve and effectively merge into a single new faculty. Well, quite clearly that new faculty has the right under the Act to have 2 faculty elected by its faculty to represent the new faculty. And it has, the dean of that faculty has a right ex officio to sit on the Senate. That faculty exists. Those seem to me to be rights beyond question. And I mean, a good way to test that is, let's say that the board said, well, no, you can't have 2 elected faculty members representing the new faculty. Faculty be up in arms. They said, well, we're a faculty. We're recognized under the university's authority as a faculty. Of course we're entitled to have 2 faculty members elected by the faculty members to represent us. The dean would be saying, of course I'm entitled to a sit. I mean, that's ex officio my right. So you've got a faculty that's entitled to those representational rights. What are these people representing? I mean, the faculties that they represented don't exist anymore. You know, they've been dissolved. They simply have no legal standing anymore. And so what exactly is it that they represent? It can't be the old faculties, they don't exist. It can't be the new faculties because they haven't been elected by the faculty of the new faculty. I recognize there might be some overlap in the voting, but you know, they haven't been elected. You know, we'll use the dean as another example. It can't be the deans of the old faculties, they don't exist anymore, and the dean of the new faculty, whoever that is, has the right to sit. So there's a pretty fundamental logical problem there, and so when I start to think about it in those terms, I think, well, the duration of the term isn't really a very satisfactory answer to those problems. And again, in my mind, it raises some fairly fundamental questions, both about what I'll call democratic legitimacy. You know, you're a senator, but you're there. I don't think you're there. You're not like an MP representing a constituency, but you're there to ensure that certain interests are brought to the attention of Senate when they're making a decision. You're a senator, so your obligation is to act as a senator, but you're there to ensure certain interests are interests the Senate's aware of. But those interests don't exist anymore. What is it you're there to do? And it raises a question, going back to my earlier example of the close vote. What if a really crucial decision of the Senate turns on 3 votes, and we've got 4 faculty members and 2 deans who happen to be around from the old faculties? That vote may be invalid, and then Kwantlen runs the risk, the Senate runs the risk of a legal challenge. We'll assume it's an important issue. A legal challenge to matters that are then undertaken as a result of that vote. And so I just think the reality is, once Senate, and it would have been a matter that involved Senate and the board, obviously, but once Senate has accepted, you know, these faculties are going to be dissolved, we're going to have a new faculty constituted, is it Faculty of Humanities? Is that what I can't remember the...
We're unsure of the name.
Okay, so we'll call it the new FAC. Once new FAC exists, that's based on the actions of Senate, among others. And those actions, it seems to me, are a decisive answer with respect to the status of these former individuals. I don't suggest that the Act provides a clear answer. It's a matter of exercising my best judgment based on the competing analyses. But I think it's pretty problematic to have people who were elected to represent faculties that don't exist, or appointed ex officio from faculties that don't exist, continuing to sit as members of Senate. It's a pretty fundamental question about the validity of their actions.
But by the Act, does the Senate have the ability to determine a timeline to deal with that issue? Because I think that there is, and I don't want to belabor this with your discussion, but I think that it's an important understanding of the Act and how it relates to the business of Senate and its ability to conduct its affairs as it sees necessary, because I don't like being told, or possibility of being told that, well, the Act says you can't do that.
Well, I think it's not the Act saying you can't do that. I think the day those faculties cease to exist, I don't know if there's a fixed date, but I think the day those faculties cease to exist, the offices, the Senate offices that were associated with those faculties cease to exist too. I mean, there isn't, we'll call them Old Fac 1 and Old Fac 2, because I don't remember the detail of it, but there isn't a dean of Old Fac 1 anymore. There isn't a dean of Old Fac 2 anymore. Those offices are gone because there's now New Fac, and New Fac has a dean. And we'll use the deans as the example. You're ex officio a member of the faculty because you're the dean of a faculty. Faculty doesn't exist anymore. So I think the date on which those faculty ceased, at 11:59 p.m., those offices cease to exist. And I think that's not set out in black and white in the Act, but I think it's a necessary consequence of the basis on which appointments or elected offices in Senate exist. That's my thought. Yes?
Sort of a similar question. Because we're compressing one of the faculties, the number of elected members of the Senate has gone down. And in the 2010 UBC case, one of the points of emphasis was, well, it was decided by this many elected people. Mm-hmm. But the Act itself doesn't, says 2 for each faculty. It never gives any guidance about how many elected members you should have.
No, that's right. I mean, but I think that it doesn't really change. It comes back in a way to a point I was making, that at the end of the day, this is a matter of law, not politics. And I don't mean that in any sort of slighting sense. I just mean that the Act is what determines the question. And the Act says the deans of the faculties, if you've got 100 faculties, you've got 100 deans. If you've got 2, you've got 2. And 2 faculty members for each faculty, same answer. If you've got 100 faculties, you've got 200. If you've got 2 faculties, you've got 4. So I just think it's a product of the Act, and it begins and ends there. So I don't know, that's probably not a satisfactory answer from the political perspective, but it's a legal issue.
Well, I'm just wondering about if we had 1 faculty.
Yeah.
So you've got 2 elected faculty, and you've got 7 or 8 non-elected, or sure.
Yeah, you could technically end up in that situation. I don't think it's a very likely outcome, though, for obvious reasons. As we'll see when we look at constraints on the board's powers, and you guys will be more familiar with this than me, having been through the exercise, but one of the constraints on the board's powers is with respect to the establishment of faculties, a requirement for the Senate's approval. So not readily going to establish or get rid of faculties without the Senate buying into the outcome. So I think that's the real protection from the sort of, lawyers like to call it the in terrorem example, the terrifying worst case outcome. But it just doesn't seem to me likely at a practical level, but also, as I say, there's a pretty clear preventative element in the University Act as well. Other questions back there? I can tell we're on like a hot button now. Okay, so just turning to paragraph 37, I think that's where we got into the dialogue. I commented there on the areas where the Senate must advise the board, and the board must seek advice from the Senate when developing educational policies. It's kind of interesting. I understand that language probably comes from the College and Institute Act, and it's kind of an interesting question in a university context about what an educational policy is exactly, not a defined term in the legislation. I'm certainly not aware of any case that deals with the meaning of it, so that's something that's probably going to be fleshed out a little bit through practice. By necessary inference, as I said, this subsection contemplates that it is the board which will develop the educational policies in question as part of its authority. But there's also a clear recognition that the Senate has a legitimate interest in the subject matter of the educational policies in question. It is important to note that both the Senate's and the board's obligations under this section are mandatory. Neither body has the option of ignoring or withdrawing from its obligations. It's also fair to say that there would be a deeply entrenched expectation in law that both bodies would discharge their obligations cooperatively and in good faith. Then I list some of the matters that are dealt with, and just touching on the point we were discussing, 3526 includes the establishment and discontinuance of faculties, and as I noted earlier, in addition, there's a fetter on the board's power with respect to that in section 27 as well. As will be evident from reviewing the list, to address these matters effectively requires consultation between the Senate and the board. The content of these matters engages both business issues within the board's jurisdiction and academic issues within the Senate's authority. The Act ensures that undertaking such consultation is not optional. Then turn a little bit to the relationship between the Senate and the Board of Governors. As I've noted above, there's a judicial expectation that the board and Senate of a university will cooperate even in the absence of an express statutory requirement to do so. Such cooperation is a mark of institutional maturity, or as I've called it earlier, governmental maturity. Kolczewski provides an instructive example of what happens when such cooperation has not been established or has broken down. The Ontario Court of Appeal noted the long-standing dysfunctional relationship that existed between the Senate and the board at Trent, and the negative impact which that dysfunctional relationship had had on the interests of Trent and its constituent elements. Just quoting now from the Ontario Court of Appeal, it appears from the material filed by the respondent university that the relationship between the academic side of the university, the Senate, and those responsible for the financing and maintenance of the facilities, the board, has historically been far from harmonious. Over time, the university's bicameral governance system, which appears to have worked satisfactorily in other universities, created fractiousness in the Trent University community and led to numerous internal conflicts. The deterioration of the governance system was one of the matters addressed by an external review of the university's administration conducted in 1997 by H.W. Arthurs and Joyce Lorimer. And as many of you probably know, Harry Arthurs was a dean of the law school I went to, very revered and senior academic figure in Ontario and probably Canada, and had obviously been brought in here as an external heavyweight. Their report, External Review of the Administration of Trent University, stated in part at paragraph 4, the fractiousness which has characterized the Trent community for over 2 decades, we suggest, reflects very real and unresolved internal conflicts. These conflicts are manifest in debates over governance structures. Trent's formal allocation of decision-making responsibility between the board, senior administration, Senate, faculty council, departments and colleges, and management resemble provisions elsewhere. However, in practice, Trent appears to have translated the informal habits of earlier and smaller days into a politically fragmented system, which, while properly anticipating widespread consultation of all constituencies, has no clear means of moving on from disagreement among them. This system, described to us as a system of multiple vetoes, is particularly problematic because of the difficulty of balancing the priorities of different constituency interests in a climate of economic stringency. Obviously, where no one with responsibility for institutional governance wants to end up in a state of paralysis, effectively. It's fair to say that in the above paragraphs, the Ontario Court of Appeal is not describing a recipe for long-term institutional success. Ultimately, the relationship between the Senate and the board requires a genuine recognition and understanding that the governance model of a university is bicameral, and that within that model, the Senate and the board are largely autonomous with their designated areas of authority and the exercise of their associated powers. At the same time, the manner in which that authority and those powers are exercised can foster or impede good governance. Which course is followed has potential implications when the board and the Senate are required by the Act to interact in the exercise of their respective authorities and powers. And in that regard, I touch in the next section on some of the restrictions on the board's powers. As with the Senate, the Act confers specific authority and associated powers on the board. Section 27 is the key section in this regard. As is noted above, the board's core authority relates to the governance of a university's business affairs. The Act recognizes that the governance of some aspects of a university's business affairs will overlap with the governance of a university's academic affairs. Given this recognition, the Act provides specifically for the Senate to play a role where such an overlap is evident. Section 27(1)D requires the board to consult with the Senate in connection with matters related to the management of a university's real property and facilities. Section 27(1)E requires the board to consult with the Senate in connection with the conservation of a university's heritage sites. Section 27(1)F requires the board to obtain the Senate's approval when establishing procedures for the recommendation and selection of candidates for appointment to positions in a university's senior academic administration, including the president, deans, librarians, and the registrar. Section 27(1)I requires the board to consider recommendations from the Senate for the establishment of faculties and departments with suitable teaching staff and courses of instruction. Section 27(1)J requires the board to obtain the Senate's approval before establishing faculties and departments. Section 27(1)K requires the board to obtain the Senate's advice when establishing certain academic positions and awards, and it may be that both the board and the Senate must think that a certain position or award is advisable before it can be established. I say that because the wording is a bit unclear on that point, whether there has to be concurrence or not. Section 27(1)R requires the board to obtain the Senate's approval when determining the number of students who may be accommodated in the university as a whole or in fact in a given faculty. And they're not just meaning living in residence. It's clear from the provisions in the section that it's admission globally. Yes?
So I have a question, sort of looking back at the historical, very clear demarcated roles of the board and governance, and then I look at section 35(2)(6), and it seems to me that with that one section, haven't we actually set up more of a conflation of those individual roles between those two bodies? Does that, you sort of talk about, well, we don't really know what educational policies mean, but I can see that section within our Act perhaps becoming one of the areas about how do we determine whose area it is if we don't even know what they mean by educational policy.
Yeah, I mean, I think it's a fair point, and so nothing I'm saying is disagreeing with the fact that it's a fair point, nor do I want to be taken as oversimplifying what I recognize are inherently quite complex challenges and sometimes driven by very legitimate interests on both sides of a point of debate. I'm kind of assuming generally good faith here, that nobody's just being disruptive for the sake of it. There are genuine and sincerely held principled views on different sides of a question. As I mentioned at the beginning, one of the challenges advising universities, which I do all the time, is the lack of case law. You work from some limited judicial guidance, from some general principles that lawyers doing my sort of work understand and apply when they're asked for advice. But I think, and it comes back to the point about the drafting, you're right. but the words have to be made to work because that's how the law works. And I think a fair comment would be that there are some specific areas where if the board is going to be developing an educational policy, whatever that might mean, I mean, all of us probably have some idea what it might mean, but whatever it might mean, if the board is going to develop an educational policy, the word educational is pretty telling there, then it has to consult with the Senate in the manner required by the statute. Some of the restrictions in Section 27 that I've talked about exist quite independently of whether the board's developing an educational policy. So, as I said, the words have to be given meaning. Judges and therefore lawyers don't like words not to mean something. The view is the legislature doesn't frivolously speak. We might not always agree with that, but that's the legal fiction anyway. And so I think the likely approach to interpreting that would be to say where the board has determined that it will issue or develop an educational policy in one of the enumerated areas, there's a mandatory advisory interaction. Separate and apart from that, in 27 are these areas where the statute imposes, the types of restrictions vary. It's approval, I think, in one case, and then various types of consultation, or in one case a recommendation. I don't remember them all off the top of my head. And so there are different types of Senate activity that are required before the board can exercise its power. That's slightly different than developing an educational policy. I think that's how that would play out. Does that answer the question?
We don't really know yet, right?
It's just a bit more than we don't really know yet. I think we know that under 27, if the board is going to do one of the things that I've touched on, that precondition, whether it's a recommendation, an approval, or a consultation, has to be satisfied. Otherwise, the board's action will be inherently invalid. Those things don't necessarily call for there to be an educational policy. Some of them are just simply business decisions. How many students are we going to admit? You know, that's a business decision, but it's also an academic decision. The Act recognizes that both sides of the bicameral governance structure have an interest. Board doesn't want to take in more students than can possibly be properly accommodated in the broadest sense of the word. The Senate doesn't want students admitted willy-nilly without proper instructional facilities being available to them. I don't mean in a physical sense necessarily, but you know, the right faculty, the right programs, and so on. They've got to consult with each other. So I think that's not necessarily an educational policy. Educational policy is a statement by the board that in relation to one of the subject matters, this is how we're going to conduct ourselves. Does that do it? Sort of. Yes?
And just for clarification, in your points, sort of 46 through 52, these are all 27-2.
Yeah. Sorry. Yeah. Typo. Yeah, thanks, Sam. And then I just touch on the fact that you've passed bylaws and procedures. The Act requires the Senate to do that, and you've done it. I don't propose to spend any time on them since you'll be familiar with them. I'm just going to close by talking a little bit about what I see as the duties of a senator. It won't surprise you, given my earlier comments, that there isn't a case that I'm aware of on what the duties of a senator are. It'd be nice if there was. It would make our lives simpler. And the Act doesn't speak directly to that. But I think general legal principles that surround the kind of functions that senators, like board members, exercise tells us something about what the nature of a senator's duties are. It is an office, and that has significance in law. It's an office which is governmental in nature, and that has significance in law. And there's a statutory requirement that the Senate's bylaws expressly address conflicts of interest. All of those things support the proposition, and I stress it's my proposition, that a senator, like a board member, is in a position of trust vis-a-vis Kwantlen. In essence, this means that a senator must act in good faith to the best of his or her abilities in what he or she judges to be Kwantlen's best interest, after taking into account the available information about a matter which is before Senate and after weighing carefully the rational arguments for and against a given outcome. I'm saying essentially, going back to a distinction that I made earlier, it's a governmental rather than a political office. A senator isn't there, in my view, any more than a board member is to represent a faction or a political interest. That's not to say that legitimate or rational arguments that emerge from the political debate that takes place in an institution shouldn't be considered, because some of those arguments are rational and principled, and they might well affect a senator's judgment about what the correct decision would be on a given issue. But it's to say that the senator's individual autonomy shouldn't be lost in the political or factional debate. And that isn't, in my view, the senator's function. And I comment on one other aspect of this, which is the elected senators, and again, I stress this is my view, it's a considered view. While those senators who hold elected office are to some degree representative of a constituency, it is probably correct to see the representational dimension of their role as providing a guarantee that the Senate will be aware of and factor into its decisions the interests of key constituencies, faculty, students, and staff, rather than as providing a mandate to advocate for the narrow or specific interests of a given constituency. In the end, every senator's paramount obligation is to act in Kwantlen's interest. Just by way of conclusion, the perils of dysfunction in a bicameral governance structure are vividly illustrated by the facts in Kolchewski. In the words of the Ontario Court of Appeal, Trent desperately needed to restructure its administration in order to cut costs and put it in a position to take advantage of a government initiative whereby scarce capital funds would be made available for capital improvements and renewal of the infrastructure. Yet, despite Trent's desperate needs, there was a sustained opposition, including opposition from the Senate, to the measures the board of Trent, acting within its authority, had resolved to take. This crisis played out against a lengthy history of dysfunction in the relationship between the Senate and the board. Given the OCA's findings about the factual background of the case and the circumstances to which the board was responding, there is every appearance of a complete collapse in the viability of the bicameral governance model at Trent. No one would argue that such an outcome could be characterized in any way as being in Trent's best interest. At the end of the day, the quality and success of the bicameral governance model and its associated processes rests in the hands of its participants. Inevitably, disputes and disagreements will arise, and not all of them will be resolved to every participant's satisfaction. At the same time, every participant in the bicameral governance process must be presumed to share a common desire to see Kwantlen flourish. The most critical contribution that any participant can make to the quality and success of the bicameral governance process is to keep this common desire firmly in mind and to act accordingly. So those are my comments today. I'm happy to take into account any other questions, discussions. One at the back.
Another question.
Of course.
The Trent case, only one of the senators brought the case forward.
Right.
So the dispute was not between the Senate.
If you read the case, you see in the background that the Senate had been opposed to the developments as well. The legal dispute was not between the Senate and the board. I completely agree. But it's, as I say, my comments are really in the context of that larger discussion, what Harry Arthur's commented on, the 2 decades of dysfunction. And as I say, I'm not in a position, nor would I allocate any responsibility there. Everybody had obviously failed.
So I was just wondering, does our Senate have the money to hire lawyers to go into disputes with the board? And does the board have money to hire lawyers to go?
I'd discourage it.
But
yeah, I mean,
does the Senate have money?
Obviously, the Senate is, at the end of the day, a creature of the university, just as the board is. I mean, at the end of the day, if the Senate thinks it needs, on a given issue, a budget for legal services, that's something to propose to the board. The board controls the purse strings. That's their area of authority. I've seen one or two cases where Senate has needed legal advice, not on a dispute with the board, and that need arose because the dispute arose in the context of the Senate's authority over matters of academic governance, and the Senate needed to get some opinion work done to determine its position vis-a-vis the challenge that was being made. And as I say, the case I'm thinking of was not a fight between the Senate and the board. I suppose if Senate resolves to ask for a budget on something, it may or may not persuade the board that the board should give it the budget. I'd be kind of inclined to discourage that as a preferred outcome, though. Yeah.
I very much appreciate the clarity of the presentation.
Oh, thank you.
Notwithstanding your comments about the somewhat representative nature of an elected senator, do you see any difference in the role of an ex officio senator, for example, the dean, versus an elected senator from the same faculty?
Yes and no, and I'm not saying that to give a difficult answer to your question. No, in the sense that I think everybody, and as I say, I'm not here to advocate a position in terms of relationships between the board and the Senate. I would say to the board the very same sorts of things that I've said here. But you'll appreciate from my comments that what I've advocated first and foremost is that every senator's role is to act in what he or she, exercising the sort of analytical and intellectual functions that I've talked about, determines to be Kwantlen's best interest. And I don't think it matters whether you're elected or appointed ex officio. That remains your obligation. I do think in our society, if somebody is elected, it's because there's a perceived value to a particular interest being represented by someone who has the support of the group which is being represented. And I think that engages a slightly different set of considerations than in the case of somebody who's appointed. So I think we'll use the students as kind of the neutral example, perhaps. The students have as one of their functions ensuring that the Senate is aware of the interests, the legitimate interests of the constituency from which they've been elected. I don't think it's their job to function as first and foremost advocates for that constituency, but I do think they play an important role in ensuring the Senate is aware of and understands the legitimate interests of the constituency. I don't see the ex officio senators as having that role. A dean, the president, the vice president academic is there, I think, first and foremost to bring to the Senate's attention what I'll call broadly the institutional considerations that the senior administrators of a university would tend to be aware of, and that those who have been elected, who, say, represent a constituency, should be factoring into their thinking and might not be aware of. So it's just a slightly different role in my mind. And as I say, I base that primarily on the fact that in our society, when people are elected, it's normally contemplated that they will be, to represent a constituency, it's normally contemplated that they will be at some level advancing the interests of that constituency. But there are nuances to that role. So I saw another hand up there somewhere. No? Yes.
So then questioning if the board is appointed primarily by the lieutenant governor of the province, where do the board members find their role in representing either the interests of the provincial government or the university to which they've been appointed?
I think it's first and foremost the responsibility of a board member to represent the interests of Kwantlen. I don't think that the board member's primary function is to represent the interests of the provincial government, regardless of who's in power. Board members at the end of the day, as you've seen, are responsible for the conduct of a university's business affairs. They necessarily have to take account of the policies of the government of the day. We don't have a country with heavily endowed private universities. They're publicly funded, and that has pluses and minuses attached to it. One of them, depending on one's perspective, one of the minuses, I'll characterize it that way, is that an institution in its business affairs is more beholden to government than it would be if it had a large private endowment. One of the pluses, obviously, is greater access to an institution that's offering post-secondary education than necessarily exists in somewhere which is more heavily dependent on private universities. But I don't think that the primary function of a board member at a university is to represent the government. They're appointed by the Lieutenant Governor and Council, but that doesn't translate into being, say, the representatives of the government. So that's my thought on that. I think they have substantially, it expressed that when I talked about the sort of role of trust there, and I think I said it in my paper, I think it's the same role the board members have. Anything else? Yes.
So Patrick, considering that the board and the Senate are acting in good faith in their carrying out their duties, and situations arise which may put you out of compliance with the Act. Two questions. One, how much leniency is given to either body to make adjustments to get through that transition period? And secondly, if you're out of compliance, what happens?
Well, if you're out of compliance, you're out of compliance. And if somebody challenges, well, I guess I'll go back to a higher level principle. In matters of governance, one shouldn't be out of compliance. That's the point of good governance, obviously, is to be in compliance. One can be inadvertently out of compliance, and that's a slightly different problem than being advertently out of compliance. But one shouldn't be out of compliance. The Act, as I think you've seen from the discussion, presents problems because it expresses, as statutes do, in fairly simple language. It's not 2 volumes of War and Peace we're looking at. Concepts or principles that have to be applied in far more complex factual situations. But at the end of the day, there has to be a best effort to determine what is required by the Act, taking into account the sort of things I've discussed this afternoon. And leeway typically isn't a big part of what statutes give people. And I don't think, you've asked a general question. I don't think as a general proposition there is in any meaningful sense, leeway with respect to compliance versus non-compliance. You're either in compliance or you're not. And if you're not, then the validity of the actions that are taken pursuant to the non-compliant state is an immediate and serious question. It's a shifting foundation, and that's a dangerous situation to be in.
But once that is realized, in good faith, you are trying to become compliant.
Yeah.
There must be an element of leeway to get to that point. I don't mean to take it willy-nilly. I think it's an important as a new university in the transition from Education Council to Senate.
Sure.
And thus all of the purposeful language that was used in the amended section, we've had to feel our way along and deal with some very crunchy issues. And I think that we've done a pretty good job of that. And there's a bunch more issues we need to face, but I think that there's a requirement that everybody have all the information to make a decision, which means you may be out of compliance. And so
you're describing an additional layer to the problem, which is that you're potentially out of compliance during a transitional phase in an effort to place yourself in compliance. I don't think that's going to, we're talking about this at a very general level. I don't think that's going to be inherently the same kind of problem as, going back to my earlier comment, advertent non-compliance. If you take immediate measures to get into compliance after you find out you're not in compliance, that's a little different than indifference or reckless indifference or intentional non-compliance. And I think people are realistic, again, against the sort of background I've described, which isn't one of black and white clarity about compliance on every issue. It's that good faith transition that matters. But say these are general comments in response to a pretty general question. Lawyers like to deal with the nitty gritty. Yeah. Most institutions that I'm familiar with have or have developed, they've either had for a long time or have developed a governmental affairs office, which is designed, among other things, for that purpose. Indeed, there was a bit of an issue across Canada when the feds introduced some lobbying legislation because all the universities suddenly found that they had to register as lobbyists because they were busy trying to persuade governments to do things. I'm just guessing, but I suspect amendments to the University Act probably aren't going to be on the top of most governments' legislative timetables. Just a guess, as I say, but again, I don't think it matters what government's in power. It's just rarely going to be one of their top issues. And I think this is maybe a kind of cold comfort, but the lack of judicial decisions around these issues should, in a way, be comforting. Most of the time, most of these issues get resolved in a way that doesn't require everybody to end up in court. And so, you've got to be in compliance. I mean, it's a statute. It's the law. There isn't an option there. If being in compliance presents the institution, again, we'll assume all the good things I've talked about, presents the institution with a genuine problem, then getting the legislation changed or getting an exemption introduced is what you have to do. And it's I don't want to overstate this, but so I'm not wanting to sort of put it too dramatically, but not being in compliance is a dangerous place to be because it calls into question the validity of everything that gets done further to that circumstance. And that can have major, major implications. As I say, I don't want to sort of, back to my earlier comment, raise the in terrorem spectacle, but there is a legal reality to that. Not being in compliance is a serious problem. And so, there's a kind of legal and now in the Victoria sense, a political dimension to the answer to your question. The legal answer is you've got to be in compliance. The political answer is persuade the government that their policy on a given matter, as expressed in the legislation, is wrong-headed.
Do so from a place of compliance.
But do so from a place of compliance. I mean, it's like anything in life, you want to play the strongest hand you've got. And not being in compliance is not a very strong hand. It's too easy to say, you're renegades, or, it's just not a very strong hand. And whereas, being in compliance and then being able to demonstrate the negative practical consequences of being in compliance is, while not necessarily a comfortable hand, a much stronger hand. If there are genuine problems, being able to point to the genuine problems is a better place to be. Yes?
I have a question around the issue of compliance, and It also has to deal with the fact that the transition between an education council and to a senate allowed for certain things. We have a group that are not a faculty, and when the transition period was over, they were allowed to stay at the table, but as non-voting. So they can participate in the discussion, but they cannot vote. Does having that group at the table make us non-compliant? So would you like specifics?
I might ask you more questions. I'm just thinking about the question for a second. Tell me a bit more about the role of the group. I understand they don't vote. I mean, the Senate must quite often have, people with some particular knowledge or some particular expertise come in as invited guests to provide the Senate with information on a given topic. That doesn't strike me as remotely problematic. That strikes me as due diligence of the right sort. I take it from your question, that's not exactly what we're talking about here. This is a group who are attending senators and functioning in all respects as if they are senators, except when things get put to the vote, they don't vote. Yeah, I think that's a little problematic myself, because I don't see where they have any standing under the Act. They're influencing debate. They're taking positions, based on what you've told me, they're taking positions on questions. It's impossible to know or predict how those positions and that advocacy might be affecting the views of those who do vote. They have no accountability for outcomes because they're not voting and they're not members of Senate. I understand, the historical reason why there's a desire to accommodate them. I don't see that as being, wrong-headed in a human sense, but I just don't see where they have any status under the Act to play the sort of role that, as I understand it, they're playing. And indeed, how big is the group in terms of numbers? I see. Yeah, so they're not academic groups as such. I realize the librarians would be have an academic dimension to their work. But the librarian is ex officio a member of Senate. I mean, that's where that constituency is represented in the composition of Senate. So the chief librarian is ex officio a member of Senate. So that group is represented. And the counselors are presumably members of staff, and staff elect two from their ranks.
The compounding issue would be that the agreement with the librarian and the counselors
Then, I have no idea about the practicalities of the situation, but then I would say, for purposes of this, they should be affiliated with a faculty that makes sense. And then the two faculty members who are elected and the dean represent their interests. But there's just nowhere, I'm not saying this facetiously, but there's just nowhere here where it says, the counselors or the librarians in the sense you're talking about. And to have the Senate as part of its proceedings, the regulation of its proceedings, say when we're dealing with a question that might touch on their interests, we will invite a representative of the group to speak to us on their interests, and that person will come and then go. That's a solution that doesn't require the artifice of associating them with a faculty. As I say, the chief librarian's there ex officio. There's a reason for that. So those are my comments. Yeah. Two hands up. Okay.
It's almost a follow-up question. It's not like who was buried in Grant's tomb.
Yeah.
Because there are other faculty members, for example, who teach cooperative education. Should every faculty member be affiliated with a faculty?
Continuing education always presents a little... cooperative education, sorry. And they're interdisciplinary, is that, sorry, I just don't know the structure.
They would teach across a couple of different faculties. They tend to service one or two faculties more heavily.
And I take it they're members of the faculty association, is that the case? It's just they're sort of free-floating, they don't have a faculty affiliation.
Yeah, but they perform many of the similar functions to a faculty member.
I don't want to get in a big fight between
No,
faculty and, yeah, I mean, I would have thought that if people are here as faculty, they should be affiliated with a faculty. You know, it just strikes me as odd that you would have people who are recognized as, in a broad sense, members of the faculty, not affiliated for some administrative purposes with a faculty. That's a comment at large. I mean, again, I don't know the ins and outs of the issue at Kwantlen, but in response to, you know, that question vis-a-vis the Senate, they're either, you know, they're either support staff, and that doesn't sound like anybody thinks they're support staff, or they're faculty, and then it strikes me that it would just be a matter of affiliating them with a faculty. I mean, it sounds like you've got a group. Again, I recognize, you know, the historical situation at Kwantlen presents challenges because you're evolving from being a university college, and before that, I guess a community college at one point, and you're now becoming a university with a very different governance model, and naturally enough, you have, you know, artifacts. I don't mean that in any pejorative sense, just artifacts of the historic structure, and you're now trying to fit them into the evolved structure. But I would have thought that if the faculty association is quite content to have them in the bargaining unit, that's a helpful beginning, and you then look at how you affiliate them on the administrative side with a faculty. It's my thinking.
Is there another question?
Yes, there was one back there. Yeah.
Thanks for your presentation, and I was really interested in your comments about the historical background for the University of Toronto. And I believe you said there that there was an emphasis on process in speech, and you gave the example of tenure questions versus not being judged so much on the substance of somebody's work, but on whether correct process is followed. And I guess the question of who's acting and who has the power to act in given situations is defined by the University Act. That's all well and clear. But, I mean, given that background, could you comment on the importance of the university establishing its own policies and the relevance of that to guide, you know, the steps it takes in enacting, you know, damage chapter?
I mean, as Gordon mentioned when he did the introduction, the universities that I spend a lot of time acting for are SFU and UVic and UNBC. So I'm primarily familiar with the sort of tenure and promotion models that they follow. Unlike UBC, which voluntarily recognized its faculty association quite a few years ago now, SFU, UNBC, and UVic remain non-unionized, although they have very, very long established faculty associations, and all of the arrangements that I'm going to talk about are the product of negotiations with the faculty. You know, it's not a unionized relationship, but it has many of the incidents of a unionized relationship. And what those policies, and again, I'm generalizing, but what those policies, it seems to me, strive to do, and of course at UVic and SFU, they're now pretty mature, those universities have been around for 50 years, is balance the institutional interests, which are largely embodied in the decanal and presidential levels of tenure and promotional consideration, with the mandate for collegial self-governance, which is a product of the sort of historical factors I was talking about. And the typical model involves, we'll assume a departmentalized faculty, a departmental tenure and promotion committee, often comprised, it's sometimes problematic in small departments, but often comprised of 5 to 7 people. and then a decanal consideration. Often in the event of a negative recommendation from the dean to the president, some sort of university-wide review committee, which again will typically have 5 members on it, and then a recommendation from the review committee to the president, who of course under the statute must recommend a tenure appointment or a promotion before the board can act. And as I say, my sense is those structures are designed to recognize, on the one hand, the institutional interest. You're not tenured in your department, you're tenured in the institution. There's an institutional interest in ensuring that tenure across the institution, while taking account of factors that attach to a particular discipline. Somebody who's teaching music or dance or drama is different than a physicist. There are going to be individual factors going to whether or not the person should be tenured or promoted that need to be considered at the departmental level. On the other hand, as I say, there are going to be institutional interests in ensuring that tenure is not granted willy-nilly in one part of the institution, but very restrictively in the other. Needs to be some consistency. And so those structures have, as they say, evolved now over quite a long period of time. They've been negotiated in the context of quite mature bargaining relationships. The faculty associations at the universities I act for are no pushovers. And so they I think reflect that the kind of balancing of interest and the evolution of balanced interests that is probably necessary to make a university work if it's going to be taken seriously as a university. So I don't know if that's, I've tried to kind of respond to what I understood your question to be about.
Yeah, I was thinking less specifically, not specifically about the issue of tenure, but just in general about the creation of policy and how important is that?
My sense is that, again, the institutions I act for are driven by policy, and I think it's quite important. I don't know if any of you have ever done anything like this, but if you're interested in this issue, SFU has a very, very good, what they call a policy gazette. You go on their website and you put that in, and you'll see all the areas in which SFU's develop policies. It's very, very well maintained, and I don't just say that because I know the Vice President Legal who's responsible for the site quite well, but again, it's mature. It's been developed over a long period of time. It's responded to challenges and changes, and you'll see that in a general sense, there's no area of a university's activity that isn't regulated by policy. And the importance of that is it gives a clear indication to what I'll call users of the system of how the institution will act in a given set of circumstances, and that's an important consideration. It's transparent, and that's an important consideration. People aren't left to guess what the institutional position is. It factors in the sort of interest that we're talking about as part of the bicameral governance model. So there are policies for which Senate is responsible. There are policies for which the President's office is responsible. There are policies for which the board is responsible and which are administered through those parts of the university. So I think that policy is extremely important. And again, going back to my comment earlier about governmental maturity, it's maybe one of the critical places where governmental maturity is reflected, but it also allows for the kind of engaged collegial debate that should lead to the lineaments of a governance structure. Yeah. Any more? I know Gordon's getting nervous because we're going to get charged like extra money for the room.
Any final questions?
there are none, then Patrick, thank you very much.
Oh, my pleasure,
for your,
Gordon.
presentation.
Thank you. Thanks very much, everyone.
Well, I think a well-reasoned, clear, succinct for 2 hours presentation, and there's a number of takeaways, I think, for us from it. The ones that really resonated with me are around the relationship between Senate and the board, and the requirement for it to be a collegial relationship, one that's marked by maturity, cooperation, and compromise. And it seems to have worked. If you take Patrick's point that there's not a lot of case law with respect to disputes between the Senate and the board making its way through the courts of Canada. So thank you very much, Patrick.
My pleasure, Gordon. Thank you.
For your presentation, and we really appreciate it.
Thanks.
Thank you.